I hope you guys are safe and well in your homes and everybody's doing good. So I know a lot of us are, just really concerned about the effects on, what could happen. And this is even before this. This is something that I've always talked to all my clients about, the importance of protecting your assets. You work so hard for it. And a lot of people's goal is to pay off their home, but they don't realize the importance of having the protection in place. Um, I recently had a seller who, or the kids actually called me because their mom had passed away, and basically left them a handwritten paper, signed. But now all four siblings are fighting over everything and stuff like that. So it's just a big mess. So just important, so that way those things don't take place in the future. Just to protect yourself, protect everything you work so hard for, and just make sure your wishes are granted, the way you guys want them. So I just wanted to thank Georgina for taking the time to spend, her Friday evening with us. She's an attorney that I've worked with for many years now, and I really like, the way she works and everything else. So I wanted to bring her on here to kind of give you guys some information about, protecting your assets, and then she'll go through her presentation. And once it's completed, if you guys have any questions, then she'll open it up to, to Q&A. So we'll just get started. Welcome, Georgina. Thank you.
Well, thank you for having me, and thank you everyone for joining us. Let me share my screen. Where's my presentation? Did I close my presentation? Hold on. Oh, there it is. Okay. Can everyone hear me and you can see my PowerPoint, correct?
Yeah. Yeah.
All right, so we're going to discuss the importance of a trust in this pandemic. A little bit about my office. My office focuses on estate planning, and that's what we're going to discuss today. Within estate planning, you have your living trust, you have your pour-over wills, financial power of attorneys, advanced healthcare directives. So we're going to focus on that today. My office also handles probate. So when someone passes away and they don't have a trust, or they just have a will, we have to initiate the probate process, and I'm going to be discussing that also. Within my real estate practice, I handle evictions, breach of contract disputes when a buyer sues a seller for failure to disclose, or I represent a seller defending them because the buyer is suing them. Also, disputes over earnest money deposit when you purchase a home and you submit a deposit and then you decide to cancel escrow and the seller doesn't want to release that deposit. Partition lawsuits. Let's say there's two owners of the property. One wishes to sell, the other one doesn't. We can actually force the sale of the property. So that's what my practice focuses on. If you have any questions, you can type them in the Q&A section or the chat, and I'll get to your questions until the very end. So with this COVID pandemic, I think it's new to everyone. We're all in the same boat, basically ordered to stay home. And those that have been affected by the virus and are at hospitals on ventilators, no one can visit them. So I think that's where having a living trust, having a financial power of attorney comes into play. Because imagine from one day to the next, you contract this virus and you're stuck in a hospital room, or you're stuck inside your home and you can't go out, and you haven't planned for the future as to how you want your assets to be distributed. That becomes a major problem. So in this slide, I discuss, if you were to lose capacity, who would have the authority to make financial decisions for you? Who would have access to your bank accounts to provide for your care, provide for the care of your children? What if your parents or you were to pass? Are your wishes written down? Have you thought how you want your assets to be distributed? So first, we're going to discuss key terms. Since I'm going to be using several phrases throughout the presentation, I want you to be familiar with those key terms. We're going to go over estate planning options. When a client comes into my office for a consultation, I always tell them you have three options when it comes to planning for the future, how you want your assets to be distributed. The downfall of adding children on title to property. A lot of people are guilty of this. After they listen to my presentation, they actually want to undo what they did. I have clients that will tell me, well, Georgina, I don't want to spend the money on a trust and I'm going to avoid probate and I'm just going to add my children on title. That is the worst decision someone can make, and it causes a lot of issues. The downfall of taking title is joint tenants, and then at the very end, some questions. So key terms, when I'm referring to assets, I'm referring to all your belongings, your home, your rental properties, your bank accounts, business interests, whether you have an LLC, an S corporation, or you're in a partnership, timeshares, and so on. A will is a document where an individual nominates an executor, a family member, to carry out the probate proceeding and list beneficiaries. This is very important. People think that by having a will, they're protected. The only thing they've done is inform the judge how they want their assets to be distributed. You still have to go through the probate process. Probate is the court-supervised process where a judge appoints an executor or an administrator to manage the decedent's assets, then distribute the assets to the individuals listed in the will if there is a will, or to the heirs at law if there's no will. So if there's any realtors, I'm sure there are, or individuals who have heard of, someone passing away and then the children right away want to sell the home, well, you can't. If there's no trust, you have to go through the probate process to get appointed. Like I mentioned, probate is necessary if a person passes away with or without a will. So then we go on to living trust. Living trust refers to anything that people call a revocable living trust, a family trust, a living trust. A trust is essentially an agreement that a single person or a married couple creates during their lifetime. In that agreement, they indicate, during my lifetime, I'm the sole owner of my assets. I can do as I please. I can sell, I can refinance, I can acquire more properties, but upon my passing, this is the individual that's going to be in charge of my assets, and this is how I want that individual to distribute my assets. Sorry, I can't see my slide. Okay, so option one. When a client comes into my office, I tell them you have three options. One is you don't plan, you don't have a trust, you don't have a will. If you have nothing in place, upon your passing, the probate process needs to be initiated. A judge will appoint a family member to manage your assets. The court is going to decide who will receive your assets. And most of the time, that's not the individual or individuals you intended to receive your assets. I'll give you an example. Let's say someone has 5 kids, and let's say it's a lady, and that lady hasn't spoken to 2 of her kids in 30 years. Guess what? If that lady passes away, her estate is going to be distributed in 5 shares. The judge is not going to ask, oh, Billy, did you have a good relationship with your mom? When was the last time you visited your mom? Did you care for your mom? No, the judge is just going to say, okay, this person has 5 kids. We distribute the entire estate in 5 shares. The entire probate process takes about 1.5 years. So what is so bad with probate? It's the fees. Besides it taking 1.5 years, it's very expensive to go through probate. We as attorneys get paid a percentage of the value of the estate. So if you just have one home, and that one home is worth $500,000. Remember, we're basing this on values right now. That doesn't mean that you're going to pass away right now. What if you pass away 30 years from now, 40 years from now? Obviously, and hopefully your house is worth a lot more by then, but that just means that the attorney's fees will keep going up and up. But if you pass away right now and your home is worth $500,000, which is very easy to meet in Southern California, I don't care where you live, it's very easy to meet that threshold. The attorney at least will charge $13,000. And the reason I say at least is that we have the authority to ask the judge to increase our fees if the case was a bit more difficult or if a house gets sold in the probate proceeding. The personal representative, the family member, is entitled to that same amount. So 13 plus 13, you're already at $26,000 in attorney and representative fees. That does not include court costs, filing fees. You have the referee that appraises all the property. If Medi-Cal files a claim, they're going to get paid before everyone. I have a case right now where Medi-Cal filed a claim for $80,000. So the children are not going to receive a dime because the decedent, the lady that passed away, she actually had a reverse mortgage. So after, paying off the loan, selling the home, escrow costs, realtor costs, the claim from Medi-Cal, there's no money. The only individuals that are going to get paid are myself and my client who has helped me administer the estate. So in that case, the kids are not going to receive a dime. So you can round this up to either 35,000 just for court costs and attorney's fees. So let's say you have one home, that one home is worth 500,000. Doesn't matter if you owe on it, if it's fully paid for, we get paid on the market value. So when people say, well, I don't really want to spend money on a trust, I'm like, okay, would you rather spend $40,000 or $50,000 going through probate? Then they look at it differently. The second option is having a will. The only difference between having a will and not having a will is that with the will, you're telling the judge exactly how you want your assets to be distributed. But you're still going to probate. So only difference between having a will and not having a will is that with a will, you're telling the judge, this is how I want my estate to be distributed. This is a breakdown if you were to sell your home in a probate proceeding and if you were to sell it in a trust sale. So as you can see, the difference is at least $30,000. So if your estate had to go through probate and you just had that one home worth $500,000 and you still owe on it, let's say $200,000, and a broker is going to charge you 5% to sell it, then you have estimated escrow fees, and then the attorney fees, a personal representative. I added $5,000 for the probate costs. The heirs would split $240,000. On the other hand, if you had created a trust and your children sell the home upon your passing, you're avoiding the probate costs and the attorney cost right here. So this is a savings of at least $30,000. And when people tell me, well, Georgina, I just have one home, I'm not wealthy, I don't need a trust. And I tell them, no, it's a greater, you actually need a trust because you don't have the extra money to spend on probate. If a millionaire passes away and he doesn't have a trust, who cares that it's going to cost them $100,000 to go through probate because that person has millions. Money isn't anything to them. But when someone says, well, this is my only asset, it's like, well, you need to save what you worked so hard for as opposed to the money going to the attorney handling the probate proceeding. The third and the best option is having a living trust. A living trust allows you to control your property while you're alive and able to do so. Just because you've created a contract indicating how you want your assets to be distributed upon your passing, that doesn't mean you lose control. You can make changes to your trust. You can sell your assets. You can refinance. You can acquire more assets. So I tell people, think about it as a bucket. In the bucket, you have your living trust agreement, which are the instructions. Then all your assets, you're going to transfer them into your bucket. How do you do that? You transfer them in the name of the trust. So your primary residence, your investments, instead of title only reflecting your name, when you pull up title on your property, it should have your name as trustee of your trust. So if you have an LLC, you should assign that interest to your trust. If you have a corporation, the share should be issued into the name of the trust, banking accounts, and your property. So everything's in that bucket. Throughout your lifetime, you can sell your assets, you can deplete your assets, refinance, sell. You can make changes to your trust. If you want to disinherit a child, those are questions that I always get asked. Well, can I change my trust when I create it? Yes, I have a trust and I've probably already changed it twice during my lifetime. So you can always make changes. Another benefit of having a trust is you can take care of yourself and loved ones if you become disabled. So a trust not only avoids probate, it protects you in the case of a disability. So if you get to a point in your life where you lack capacity, you lack the ability to make financial decisions for yourself, the successor trustee, the adult child or family member that you have nominated as a successor trustee, can actually step in your shoes and manage your assets. So think about your parents. Let's say they get to an age where they lack capacity and they become ill, and you either want to refinance their home or sell their home to take care of them. You're not going to be able to do that if you don't have a power of attorney or a living trust. On the other hand, if your parents' assets are in the name of the trust, they lose capacity and their home needs to be sold because it's too big, or it's a 2-story home, or they need money to provide for your care, you as a successor trustee can sell their home. You can refinance, get an equity line, do as you please, so long as that money is used for your parents. Give away your assets to certain individuals with your own restrictions. With a trust, you can control how and when your children will receive their inheritance. If you have minor children, you probably don't know if they've matured properly, or if they're going to mature properly, or if they're going to be responsible. So you can actually stagger the distribution and indicate in your trust, at the time my child is 25, I want them to receive 50% of their inheritance. And by the time they're 30, the remaining balance. That doesn't mean they're not entitled to receive money from the trust beforehand. Let's say you pass away and your child is 17. At that time, your child is applying to college. The trustee can use the trust money to provide for your child's tuition, books, room and board, whatever the case may be, but your child is not entitled to an outright distribution. Because if they are, they're probably going to be in Vegas every single week at the pool parties, driving the most expensive car they can find at a dealership. But if you're able to restrict when they have access to their inheritance, you're able to safeguard what you worked so hard for during your lifetime, without unnecessary cost or undue delay. Only a properly funded and properly drafted trust avoids probate. Clients will come into my office and say, Georgina, I'm protected, I have a trust. But then I look on title and their assets are not in the name of the trust. It is not enough to name your assets in the trust. That does you no good. You actually have to formally transfer the assets into the name of the trust. And I actually, mentioned that earlier, where your primary residence, your investment properties, title needs to be transferred from your individual name to the name of the trust. Your checking and savings accounts should be in the name of the trust. All business interests should be in the name of the trust. So everything's in that bucket. You pass away, you hand that bucket over to your successor trustee, and then they can follow your instructions. A lot of the times the assets fall out of the trust because during your lifetime, you either refinance and the lender says you have to take the title out of the name of your trust. So then it falls out of the trust. So these are the benefits of having the trust, and it's the best option out there. What is the difference between a living trust and a will? A will is a golden ticket to probate. A living trust avoids a costly and lengthy probate process. Living trust protects you in the case of a disability because if you lose capacity, your successor trustee would be able to step in your shoes and manage your assets for your well-being. So if you have a business, your successor trustee would be able to close down your business, collect any money that is owed to you, do all that kind of stuff. A will does not plan for disability. So if your parents don't have a power of attorney, don't have a trust, and they lose capacity, you're going to have a very difficult time being able to manage your assets. You're going to need to file for a conservatorship in court, and it's very expensive and time consuming. With a living trust, Medi-Cal liens are avoided, and this is a huge change. As of January 1st, 2017, so about 3 years ago, Medi-Cal issued an order, and Medi-Cal said, if someone passes away and they have all their assets in the name of the trust, we are not going to seek to collect from their estate. So if you have a trust and you received over $100,000 in benefits because you had 10 procedures before you passed away, Medi-Cal is not going to seek to collect. On the other hand, if you just have a will or no will and probate is needed, Medi-Cal will file a claim. We as attorneys cannot legally close a probate proceeding without showing proof to the judge that we have notified Medi-Cal and Medi-Cal told us that they do not have a claim against this estate. With a living trust, blended families are protected. You know, nowadays we have families that have children from different relationships. If you don't have a trust, you're possibly disinheriting your children. And I'll tell you why. Let's say husband has 2 daughters from a previous relationship. Wife has 2 sons from a previous relationship. They get married, purchase a home, and they acquire title as joint tenants with the survivorship, meaning that upon the passing of one of them, the title goes to the surviving joint tenant. So if husband passes away first, his 2 daughters are disinherited. It doesn't matter that husband has the will saying, my house goes 50% to my daughters, because we're not going to need to initiate probate. By operation of law, the second husband passed away, 100% of that property went to wife. Wife can decide, to prepare a will or a trust and add those daughters as beneficiaries, or she can decide to sell that home and keep all that money. So just by you having a will listing your children as beneficiaries doesn't mean that they're going to receive an inheritance, because like I said, a will is only used when you initiate probate. But if by operation of law of how title is held or because there's a beneficiary designation, probate may not be necessary. So those of you that are part of a blended family, whether you have children from different relationships or you yourself are a child that's part of a blended family, you need to make sure your parents have their affairs in order, because you possibly can be disinherited. So with a trust, that gets prevented because we can outline in a trust, okay, when husband passes away, his daughters are entitled to a certain percentage, or the entire trust becomes irrevocable and the surviving spouse will not be able to make changes on the trust. So adding your children on title to your property, that is a great way to have your children's creditors go after your property. So I will encounter clients that will tell me, Georgina, I've added my children on title because I don't want to go through probate and I don't want to spend a couple $1,000s creating a trust. That is a recipe for disaster. By adding your children on title, they own your property. If they have any creditors and a creditor obtains a judgment against your children, guess what? They're going to run a title search. And with today's technology, they don't even have to pay any services to be able to find out what assets someone has. So a judgment can be recorded against your property. If you ever try to refinance or sell, you're going to need to obtain your children's permission. As a result of you adding your children on title during your lifetime, your children will have to pay capital gains taxes when they turn around and sell the property. Why? Because they inherit your tax basis. I'll give you an example. Let's say you bought your home, and at that time the home was worth $200,000. You added your children on title, and by the time you pass away, that home is worth $700,000, because remember, at least 40 or 50 years have passed since you purchased the home. If your children were added on title and they turn around to sell the property, they're going to need to pay capital gains taxes. That would be calculated by taking into account the difference between the sales price of $700,000 and $200,000, your initial purchase price. So their gain is $500,000. That, they're going to have to pay that, capital gains taxes on that amount, because they were added on title during your lifetime. As opposed to someone inheriting a property, the value gets determined at the time of your parents' passing. So if your parents pass away, the home is worth $700,000. You inherit that home, you turn around and sell it, your gain is literally going to be zero, and you're not paying capital gains taxes. So that is one of the greatest mistakes people make. Instead of helping themselves and their family, they're passing along this huge tax bill to your children. Like I mentioned, adding your children on title, you lose control of your property. If your children get married and then file for divorce, guess who's going to be involved in that divorce proceeding? Guess who's going to be added as a party to that divorce proceeding? You are. Why? Because your child's spouse is going to claim that that asset is a community asset because it was acquired during marriage. I've seen it happen, and it's horrible. I've seen cases where parents actually give a gift of equity to their children. They sell their home to their child, or they add their children on title, and they're just involved in the divorce proceeding. And with the divorce rate being so high nowadays, it's very likely that you will be a participant in that case. So here's what I was discussing regarding the capital gains taxes if you add your children on title, just so you can see it. So in this scenario, parents purchased a house in 1986. At that time, the home was worth $250,000. The parents add the children on title in 2010. Parents pass away in 2040. At that time, the house is worth $700,000. The children sell it at that time for that amount. Their capital gain is $450,000, which is the difference between the sales price and the value at the time the parents purchase it. Capital gains taxes combined with federal and state is about 40%. So your children will have to pay about $180,000 in capital gains taxes. On the other hand, if you inherit the home, capital gains tax is zero, because you inherit the home and it's worth $700,000. You turn around and sell it for $700,000. That's zero. How about taking title as joint tenants? We do not live in a perfect world. So let's say you and your spouse took title as husband and wife as joint tenants, or husband and wife as community property with the right of survivorship. Yes, upon the passing of one of you, the surviving joint tenant keeps 100% of the property. But what if at that time there's no surviving joint tenant? Let's say both of you went on a trip to celebrate an anniversary and you were in an accident and you don't make it back. Who is a surviving joint tenant to keep ownership of that property? There's no one there. Or what if by the time one of you passes away, the surviving joint tenant lacks capacity? They lack capacity to prepare a will or a trust, then that's going to go through probate. And like I mentioned, having title as joint tenants does not protect a blended family. And then also individuals do not understand the legal implications that if you took title as joint tenants, whether it be with your spouse or a family member, upon your passing, 100% of that property goes to the surviving joint tenant. So this is a good time for all of you to review how you hold title, especially if you own any property with any family members, like siblings, because if you hold title as joint tenants and if you pass away, you're just inheriting your children. Whoever is a surviving joint tenant keeps 100% of that property. And like I mentioned earlier, adding children on title as joint tenants will cause issues. So that's why I don't recommend taking title as joint tenants. So with my estate planning portfolio, what does it include? You get the revocable living trust. My trusts are about 100 pages. We outline who is going to be the successor trustee. We also list an alternate successor trustee in case that person is not available. Each of you gets a pour-over will. The purpose of the pour-over will is to make sure that if probate is necessary, everything will go into the name of your trust. So you're telling the judge, Your Honor, I have a living trust. If I pass away and something was left outside of the name of the living trust, make sure that you transfer everything into the name of the trust. Each of you gets a financial power of attorney. My financial power of attorneys are about 25 pages. I know a lot of people download their power of attorneys from the internet, and then when the children are trying to use them to like sell a property, the title company is not so willing to honor them. Why? Because the power of attorney has coffee stains, there's scribbles all over it, and the title company is assuming a lot of liability because they were not there when that power of attorney was executed. On the other hand, if a title company sees a power of attorney that was drafted by an attorney, it's notarized, it provides more security. Okay, there was an attorney involved. An attorney explained this power of attorney to the individual, and they understood the legal implications of having one. You also get an advanced healthcare directive. If you're unable to make medical decisions, you have nominated someone to make those decisions, and you can be very specific as to what you want done and not done. You know, some people are very adamant, I want to be on life support for 3 months at least. Others say, absolutely not. If I'm going to be in a vegetative state, I don't want life support. So the trust avoids probate. The financial power of attorney avoids the need of a conservatorship of the estate. Remember earlier I mentioned that if someone lacks capacity and their children are trying to sell the property, they're not going to be able to sell it unless there's a trust or a financial power of attorney. The Advanced Healthcare Directive avoids the need of a conservatorship of the person, because if someone lacks capacity and medical decisions need to be made and there's no Advanced Healthcare Directive, you need to go in front of a judge. We prepare the deeds and we record them, transferring ownership into the name of the trust. Some questions that I get asked all the time are, Georgina, do we need to record our trust with the recorder's office? No. The trust is confidential in nature. You yourselves are the only ones that keep a copy of the trust. The only thing that becomes a public record is the deed transferring ownership from your individual name to the name of the trust. So if someone pulls title on your property, all that they're going to see is that you have a trust. It's not going to list who the beneficiaries are. And it's not going to list, the extent of your estate. It's just going to mention that that house is owned by your trust. Like I think I did mention, a trust can be amended at any time during your lifetime. If by the time someone passes away, there are no assets in the trust, then there's nothing to distribute. Another question I get asked is, Georgina, do I have to make changes to my trust every single time I buy a new property? The answer is no. My personal recommendation is to list percentages. So that way, whatever is left at the end of the day, it will be divided according to the percentages you have listed in your trust. So that way, if you buy another property, all you have to do is make sure that title is in the name of the trust. So as long as everything at the time you pass away, it's in the name of the trust, you're not going to go through probate. The trust will control as far as how your assets will be distributed. Let me see here. What is the next slide? So what is the fee? At my office, obviously we prepare trust. The price for a single person with one home is $1,649. And that includes all the documents I just listed and others. For a married couple with one home, it's $2,499. Each additional property is $250 because we need to prepare the deed and pay the recording fees. Oh, I think that's the end of slideshow. So I think I'll stop sharing my screen and open it up for questions. Okay, I don't think anyone has, let me see, where is I can't see the Q&A.
Oh, does anyone have any questions in the chat? It's in the chat room. Can you see the chat?
Yes, I can see the chat.
You can either unmute yourself or you can type it in. It's up to you guys if you guys have any questions at all.
Hey, I have a question.
Yes.
This is Bonnie. I already have an advanced health directive and a will.
So if you only have an advanced healthcare directive and a will, that means that if you were to lose capacity, let's say 20 years from now, you're in a car accident, you lose capacity, there's no one there to make financial decisions for you. And then when the time comes and you pass away, your children, if you have any, or your family members would have to initiate the probate process to get your will admitted into probate. So if you have a will that says, okay, all my assets go to these individuals, they're going to have to pay a good chunk of money just to go through probate, depending on how many houses you have, how many accounts you have, and so on. So you definitely need a trust in order to avoid probate.
Okay. Thank you.
So I see a question here from Vanessa. How should you take title versus joint tenant? If you're married, I would recommend having a trust. But if you don't want to create a trust, then you can take title, husband and wife, as community property with the right of survivorship. The downfall of that, like I mentioned, is if you're part of a blended family, or if you have a special needs child, they can possibly lose their funding because they're going to receive an inheritance outright. And what if you and your spouse both pass away? Who's the surviving joint tenant? And even if one of you survives, what if you lack capacity? So best way to hold title is in the name of your trust. If you don't want to create a trust and you want to risk it, then husband and wife as community property with the right of survivorship. If someone already has medical benefits, can they still get a living trust? Absolutely. So long as you create your living trust prior to your passing, obviously that would be a requirement, you're good to go. So if you have received Medi-Cal benefits or you are ill and know that in the future you will need to have some procedures or hospital stays would be involved, it's advisable that you get a trust. What is the best way to take title for a married couple? Husband and wife as community property with the right of survivorship if you don't want to do a trust. What should domestic partners file and how? Are you talking about, Rosemary, domestic partners that are registered as domestic partners, so they're not married?
Well, they're not married, and in our case, we're domestic partners, but sorry about that background noise. That's our 3-year-old. We are indeed a blended family. And I know that to be a registered domestic partner, there's also several other implications. So how would we go about doing a living trust?
So since you're not married, you don't file your taxes jointly, right?
No.
You each would have to create a living trust and transfer your respective interests into your trust. So for example, I'll refer to you as husband and wife to make it easier. So husband can say, we'll just pretend you have one house. You would transfer your respective 50% interest into your trust. So husband can say, okay, upon my passing, my wife has the ability to live here as long as she wishes. But once the house is to be sold or she passes away, I want my child from my previous relationship to get a certain percentage. Or you, wife, you can say, well, upon my passing, I want 30,000, 40,000 to be given to my child that I had from a previous relationship immediately. So there's really no right or wrong answer. It's what works best for you. But if you're a blended family, you need to have a trust, each of you. Because even if you hold title as tenants in common, your interest is going to go through probate, and then it's just going to be a different outcome. And you definitely want to protect your children and each other.
Correct.
So does that answer your question?
Yes, it does, Georgina. Thank you.
So next we have Stephanie. Holding a joint tenancy is 2 or more people. Yes, because remember, there has to be a surviving joint tenant. So the legal definition of joint tenancy is 2 or more people having equal ownership in a property. So it gets very tricky when people that are not married hold title as joint tenants. I was guilty of that, with one of my brothers. I actually held title as joint tenants, and I didn't even realize that until I was in law school. So you definitely need to, what you do is you transfer your ownership interest into your trust. So if you do have an investment property with a sibling, a friend, we would transfer your 50% interest into your trust. Susan, what if I own a home and they get married and then pass away? So if you own a home, get married and pass away, don't have a will, don't have a trust, probate would need to be initiated. Depending on whether you have children or not, will, I guess, affect how much your spouse will receive. So if you have no children, your spouse will get a certain percentage, and then your parents would also get a certain percentage. Jessica, can a trust be made if the person isn't fully capable of making decisions? Absolutely not. So that's why I always advise people to do it while they're able to do so. I always get children bringing in their their parents, and just by asking them a few questions, I realize that they lack capacity. So legally, I cannot create a trust if they lack capacity. The capacity to create a trust is much higher than that to create a will, because with a trust, you're creating a contract. So the person needs to understand the legal ramifications of creating a trust. If there's a power of attorney that specifically authorizes the person to create a living trust, then yes. But I can guarantee you 99% of the power of attorneys out there do not specifically give the person the right to create a trust. It may say this person has control over my will, my trust, my estate planning documents, but it needs to specifically state my agent has the authority to create a trust on my behalf. Claudia, so if you have a child with a disability and you want to leave everything to them, how do you go about having them inherited without none of their benefits being affected? You would do a special needs trust. You would create a trust, and the distribution for that child, whether it's 100%, 50%, would be in a general needs trust so they don't lose their funding. Jackie, if you have different life insurance policies that will be split in 3, how will that work on the trust? Will it get distributed only to the trustee? No. So with life insurance, you have 2 options. One option is you leave it as is with 3 equal shares, or you list the trust as the beneficiary. If you list the trust as the beneficiary, which is my preference, the trustee receives that money and distributes it in 3 shares. The benefit of it going to the trust is that whatever restrictions you have placed on the distribution for your children, those would apply to the life insurance proceeds. So let's say you have 3 kids and they're under the age of 25 and you've listed them all as beneficiaries. You pass away, that money goes directly into their bank account. So if they want to go buy an expensive vehicle or go to Vegas every single week, they can do that. However, if you list the trust as a beneficiary and the trust says, my children are not entitled to an outright distribution until they have reached 25 or 30, then they won't have access to that money outright. They can still use that money for their education, healthcare. You know, what if they go to an expensive college? Then the trustee can pay for all the tuition and your children won't have any debt. Lupita, is there a living trust? And if there's a living trust and the bank accounts are not put in the name of the trust, but the property is in the name of the trust, can Medi-Cal file claim benefits? Yes. Medi-Cal can file a lien against bank accounts. So if there's no beneficiary listed on those bank accounts, Medi-Cal will file a claim. And it all depends how much money you have in those bank accounts. If you have over 160,000 in all your accounts cumulative and they're not in the name of the trust, you're going to have to go through probate or your children will. If there's under 160,000, there's a form that the trustee can fill out and that money gets distributed to them. But Medi-Cal would be able to file a lien against those accounts. Sonia, is a bank account required for all trust accounts? Is a TIN number required? When you sell through a trust, is the money taxed? So my personal recommendation is you should have all your accounts in the name of the trust. However, I know that some banks are very difficult to work with, that if you want to transfer your accounts in the name of the trust, they will force you to close out your accounts and open new accounts. So obviously that messes up your automatic payments. I have Wells Fargo. So when I went to transfer my accounts into the name of the trust, very simple procedure. When you create your trust, tax ID number is not required. It is your Social Security. However, if it's the children selling the home through their parents' trust, a new tax ID number is required because the Social Security number dies with the person. You can list more than one successor trustee, but if they're not in agreement, it's just going to cause issues. So I always tell people, just list one child as a successor trustee, the one that you trust the most. Can you have a special needs trust and a regular trust? You would have the special needs trust within the regular trust. So your trust would be a regular trust, and then it would indicate that when you pass away, your trustee will create a special needs trust for your child. Any other questions? I think if I didn't fully answer your question, let me know. Oh, here we go. If you own a home and want to add a domestic partner, but he's an illegal alien, how can I add him to my property? So you can add anyone to your property. You know, your status is not checked once someone is added on title. You know, there's so much fraud going on that sometimes people add these individuals that don't even exist to title. So status is not relevant. Georgina, please repeat the comment about naming the child that you trust the most. Yes. As a successor trustee, you will list the child that you trust the most, that you know would do the right thing. Remember, just by listing someone as a successor trustee, that doesn't mean that all your assets go to that individual. All that means is that individual is in charge of your trust and they need to follow your instructions. So if your instructions are 50% to my 2 children and this one is the trustee, your trustee doesn't get a bigger cut. You know, the trustee can charge for their services, but they need to follow your instructions. Do you also provide consultation for Spanish-speaking clients? Yes, I am bilingual. If anyone requires a consultation, right now they're all being handled over the telephone or Zoom. The fee is $80 for a consultation, and you can book it online. Susan, you said you have a question?
Yes, I wanted to ask you, so if you own your home and you're single, and then you meet someone and you get married, and then say you're with them for 5 years, then what happens with the home at that time? If I had the home for 25 years before I even met this person, and I do have three older daughters, like that are over the age of 18. So I'm just saying hypothetically, if I didn't have anything in place, what happens at that point?
So if you don't have anything in place and it goes through probate, your spouse would get a third and your daughters would split 2/3. In this case, I would advise you to have a prenup or a post-marital agreement if your intent is for your spouse not to have an interest in that home. Because just by the fact of you acquiring something before marriage doesn't mean that your spouse doesn't have an interest. The second you get married, your salary is a community asset. So if you're using your salary to pay for your home, your spouse has an interest in that home. It may not be 50%, but he will have an interest. On the other hand, if you have a home before marriage, you rent out that home and the rent fully covers the mortgage, then your spouse wouldn't have an interest. But if you're living in that home and your salary is being used for the mortgage payments, he would have an interest. And if you have nothing in place, he would get a third.
Okay, and what about if I did have a living trust in place for my 3 girls, and then someone came into the picture? Now, does that affect that trust or that home if I'm using my income to make the payments?
Yes, they would still be able to file a claim against the trust. So let's say you have a trust, then you get married, your spouse would file a petition in the probate court saying that you forgot to list them because you created the trust beforehand. So what you need to do is a premarital agreement or postmarital agreement that each of you has the absolute right to create your own estate planning documents.
Okay, and then one further question. If you need a prenup, how much does that cost?
Normally, it depends how extensive they are. I don't practice family law, but I do prepare prenups all the time. The average cost is about, I would say, $2,000.
Wow.
Yeah.
Well, that's a lot
what
of
is-
information. That's a lot of great information.
Yes, and some people don't realize it, and then they get married and things go wrong. But you really need to sit down and think how everything's going to play out. What is the difference between a family trust and living trust? It's just the name. There's no big difference. What controls is what's actually in the agreement. Can a parent leave all assets to spouse, thereafter spouse leave a child in a bank institute? Each trust is different, so whatever you want to do in your trust, you can do. Jessica, if you own a property with a sibling, how would you advise to hold title if it's not as joint tenants? That sibling would transfer his interest into his or her own trust. If you're not going to do it as joint tenants, then tenants in common, and then you would go to probate. Rosemary, may we also include special requirements in case there's a younger child? For example, asking for funds, money to be used for specific purposes? Absolutely. You can do as you please in your trust. Claudia, just clarifying question, is common law valid? I'm assuming you're asking common law marriage. Common law marriage does not exist in the state of California. You legally have to be married. So just because you're living with someone and have 10 kids with them and you tell everyone that you're married, that's not enough to be considered husband and wife. Georgina, what if you have a live-in boyfriend? Kick him out. No, just kidding. Who contributes towards mortgage, but my home is in my trust. So Marlena is asking that she has a live-in boyfriend who contributes towards the mortgage, but the home is in her trust. First and foremost, the court is going to, if he tries to assert a claim against your trust, the court is going to ask if there's any oral agreements. You know, what if he contributes towards the mortgage, and that amount that he contributes to the mortgage sort of equates what you pay for utilities and insurance. So there's actually a court case that held that if one party paid for certain stuff while the other one paid for the other, and there was an understanding that they jointly owned the home, an oral agreement can be enforced between the parties. I have actually drafted agreements between individuals that are in a relationship and live together where they say, okay, well, I'm going to contribute towards a mortgage, but I'm not going to claim an interest. So it just depends if you have some type of agreement. You know, I've encountered cases where one party pays the mortgage and then the other one pays all the utilities, all the insurance payments. So then there was one of the parties expected to have an interest in the home. So you may want to have that conversation and have something in writing that even though they're contributing towards the mortgage, that is their rent, and they're not going to claim an interest in the property. Lupita, I was under the impression that if you live with someone longer than 7 years, it's common law marriage. No, Google gave you the wrong answer for common law marriage. Common law marriage does not exist in California. You actually have to be legally married. So issues arise when someone is living together with someone else, they think there's common law marriage, and one of them passes away, and there's no will and there's no trust, then they won't receive anything in the probate proceeding. Any other questions? Now that I scared everyone and bombarded you with information, so any other questions? I know it's a lot to take in, but it's definitely good that you're taking the time to learn about this, because you know, you may be engaged in some type of conduct and you don't really understand the legal implications.
Share your information, and then I'll send you guys pictures of her her business card as well, so you guys can reach out to her and make an appointment. Very easy system that she has in place to make an appointment with her. So really nice. But I'm glad you guys enjoyed it. I'm glad you guys are drinking while you're watching.
Yeah.
It makes it a little bit
More to
easier.
drink now.
What?
I need more to drink now.
I scared you, Marlena.
I was gonna say, you guys, I just did my trust last year, and it literally cost me $2,500. So Georgina, your pricing is really, really good. So
Okay.
I'm referring you people because I get asked all the time.
Thank you. Because you're single, right? So
One property, single person.
mhm.
And just so you guys know, Marlena works in title, and so she knows the importance of having your title together. I got a call from one of someone who's on the webinar right now this morning, telling me that they were going to just do a deed. She bought the home when she was single by herself, and she was just about to add her newly married husband as a joint tenant, but she saw that I was hosting this, so I told her, you need to watch, because you need to see why, you know, that's not advisable. So I'll be reaching out to you after so we can talk about that. But thank you so much, Georgina. I mean, this is great information, because a lot of times we think we know because our neighbor's mother's brother told us it was that way, or someone else said this is how it's done. And, you know, we see a lot of people think they could just go to Office Depot and, you know, and get the quitclaim deed or whatever deed and fill it out and it's good. So it's important that, you know, it's always done right. Like I said, Marlena knows firsthand. We've had so many issues with title, especially if the person is deceased now, and that deed was signed, you know, out of an escrow, so it's not insured. So there's just a lot of stipulations. Living trust, way to go. So it just makes sense.
There's some really sad cases where, you know, you've had maybe a couple that's been together for umpteen years. We're talking 30 plus years. And that house goes into probate, like, you know, and that lady it's usually the female has nowhere else to go. And, you know, the man has been taking care of her all these years. It's sad. And even your clarification about grant deeds and how to take title is huge because like we're not supposed to give legal advice just like you, but when a client will ask me, Marlena, what's the best way to take title? We've always said a joint tenancy is the way to take because of right of survivorship, right?
Yeah.
But in this case, yeah, it makes more sense. You need to have that trust.
We do.
Yeah,
and
and I
if we
think
don't
with
do the
blended
trust,
families, too.
then husband and wife, for tax reasons, because the spouse will get taxed if she acquires 50% of the property through joint tenancy. So if they're married, has to be husband and wife as community property with the right of survivorship. But the trust is obviously much better.
Yeah, it is. Because it goes over more than just your home. Because you have bank accounts, like she's saying. If God forbid something happens, you know, now your mom has all this money in her account. You can't do nothing about it. The money's there, so it makes sense.
All right, well, thank you for having me.
Thank
I think
you so
I
much
answered all the questions, right? Well, everyone stay safe and healthy, and we're going to get through